This Honorable Court of Tennessee is now in session.
Welcome to the October session of the Court of Criminal Appeals for the Eastern Division. On the panel today is Judge Camille McMullen from Memphis, Judge Jill R.T. Ayers from Clarksville. I am Kelly Thomas from Maryville. We appreciate the assistance of Francesca Kraft and Nick Morgan in making all this work and getting the lawyers in and out and us in and out. As per usual, there will be 20 minutes to the side for the arguments. If you want to reserve some rebuttal time, let me know when you begin. We have no preliminary matters, so you may call the case, please.
State of Tennessee versus Robert Atwell.
Mr. Lockett.
Good morning, Your Honors. I would like to reserve, I think, 10 minutes, if I have that much left, Your Honor, after my initial argument.
Sure.
May it please the court. Your Honors, there are three issues, I believe, in this case today. One, did the trial court err by refusing appellant's offer to stipulate that he was a sexual offender, and then allowing the state to present to the jury evidence of the specific prior offenses that resulted in appellant being on the registry? I respectfully submit that the admission of that evidence was undoubtedly error. So that brings us to the second issue. Did that error, more probably than not, have a substantial and injurious impact on the jury's decision making? And I again respectfully submit that the answer to that question is yes. The third issue was prosecution of the appellant plain error as a violation of the ex post facto clause as contained in both the Tennessee and the United States Constitutions. As to the first issue, the Tennessee Supreme Court has made it abundantly clear that when an element of a crime is a status offense and the defendant offers to stipulate to the status offense, it is error to allow the state to place evidence of the specific crime before the jury. The Supreme Court announced that in State v. James in 2002, and that is still the law in the state of Tennessee. The status element in State v. James was simply that the defendant was a felon. In State versus Wrigglesworth, this court applied the holding in James to a sex offender registry case with the exact same result. This court, sitting in Nashville, held that the jury should be told of the defendant's stipulation. And I'm quoting here, and the state then would not be allowed to present proof of the offense for which he had been convicted, close quote. At trial in this case, the state convinced the trial court that the opposite proposition was the law, that the state could refuse appellant's offer to stipulate his status as a sexual offender and was entitled to present proof of the specific offenses for which he had been convicted. Now, the state argues that any error committed in allowing the jury to see and hear proof of appellant's specific prior offenses was harmless. Not only did the state argue verbally to the jury what those specific offenses were, Your Honors, but Exhibits 2 and 3 in the trial court record are documents from the state of Missouri where these convictions were rendered. And those documents were admitted into evidence over the appellant's objection at trial. That same argument, as made by the state in its brief that this error was harmless, has been rejected by the Tennessee Supreme Court. The facts in this case are relatively benign. Basically, appellant, who was a registered offender in Missouri, accompanied his girlfriend to register her minor son for the first day of school at an elementary school in Washington County. Under Tennessee registry law, a registrant being on school grounds where children under 18 might be expected to be present is a violation of the statute. Appellant offered to stipulate his status as a sexual offender, which meets the status element of the offense for which he was charged. That's what was contained in the indictment. The state refused and instead presented to the jury the documentary evidence I mentioned a moment ago in the form of exhibits 2 and 3. Exhibit 2 reciting that appellant had sexual contact with a 12 or 13-year-old child. And exhibit 3, a separate offense, reciting that appellant was sentenced to 3 years in prison for a sexual offense. It is absurd, I respectfully submit, to contend that admitting such proof into evidence is harmless. In State versus Rodriguez, our Supreme Court articulated the standard for judging whether evidence is in fact harmless. And this is basically interpreting Tennessee Rule of Appellate Procedure 36D, which is where the standard is contained for non-constitutional errors in the admission of evidence. The Supreme Court said, where an error more probably than not had a substantial and injurious impact on the jury's decision-making, it is not harmless. In assessing just how substantial and injurious the impact was on the jury, in this case, in hearing evidence of appellant's prior specific offenses, the Supreme Court also observed in Rodriguez that, and I quote, "There is no subject which elicits a more passionate response than the exploitation of children. Society abhors, and rightfully so, the victimization of the defenseless child," close quote. The state fought long and hard to be allowed to put just such evidence before the jury at the trial of this case, well aware of the passionate response such evidence would evoke.
What were the decisions that the jury had to make that this evidence would likely impact? What are the elements of the crime charged?
The elements of the crime, Your Honor, is that the appellant was in fact a sexual offender, and that he entered onto the premises where he was forbidden to go.
Which nobody disputes that, correct?
Correct.
So how would knowing what his convictions were impact the jury's decision on those two elements of the offense?
It was simply from an emotional standpoint, Your Honor.
But he admitted it, right?
He conceded that he was, well, he tried to concede that he was a sexual offender, but that was refused by the state. He did admit that he was on premises. He also offered up a defense.
Okay.
Under the statute.
And what was the defense that he offered under the statute?
That he was acting in the role of a surrogate parent or guardian, which is an exception to the statute.
Okay. And he put on proof to support that, I presume.
He testified, Your Honor.
Yeah. And did the child's mother testify?
She did.
Okay. Then the same question. how would knowing what his prior convictions were, as opposed to just knowing that he is a sex offender, impact the jury's evaluation of whether or not he was a stepdad or a adoptive parent or whatever for the defense you've talked about?
Well, Your Honor, I respectfully submit that who knows what a jury uses once it retires for its deliberations.
Well,
To
we've
make a
got to kind of
decision.
decide that, don't we?
Well,
You're wanting us to decide that.
well, no, Your Honor, I'm not. I'm not wanting you to speculate on what was said in the jury room. I'm asking you to specifically look at what has previously been announced as Tennessee law on this subject and derive a decision from that. And the state is arguing, this case is de novo on the law. That's the standard of review. And the state is arguing that the error was harmless. I'm saying that under Tennessee law, it absolutely could not be harmless. And since it was error, that simply results in a reversal. That is the state of Tennessee law. And that's my argument today.
Okay.
As the Supreme Court noted in Rodriguez, the state's purpose, and I'm quoting, the purpose in doing so cannot be doubted, close quote. There could be no doubt why the state fought so hard to put this evidence before the jury.
You've got about 8 minutes of rebuttal time left.
Thank you, Your Honor. If there were any doubt in the instant case, it was removed during closing argument when the state specifically drew the jury's attention to exhibits 2 and 3 and asked the jurors to, quote, review where appellant was convicted of these sex offenses that placed him on the registry to begin with out of Missouri, close quote. So it's obvious that what the state was doing was not trying the defendant on the elements of the offense charged. He was trying him on these prior offenses. In the instant case, the state also argues that erroneous admission of the past specific crimes was harmless because the evidence of appellant's guilt was overwhelming. That same argument was made in Rodriguez and rejected by our Supreme Court. Based on the applicable Tennessee precedent, it is clear that the error in admitting specific crimes and allowing that to go to the jury meets the standard. It more likely than not caused a substantial and injurious impact on the jury's decision-making. Now, the second prong of the harmless error calculus set forth in Tennessee Rule of Appellate Procedure 36D is whether the evidence would result in prejudice to the judicial process. And that's a separate standard in and of itself. The state represented to the trial court that decisions stood for propositions exactly opposite to the true holding in those cases, which resulted in the erroneous evidence being placed before the jury. As I said earlier, the state then compounded that error and the prejudice by emphasizing that evidence in his closing argument. To characterize this evidence as harmless would be prejudicial to the judicial process. To countenance what the prosecution did at trial by holding that the error was harmless would be to encourage prosecutors to routinely seek the admission of evidence they know is inadmissible. It also entails the very real risk of trial judges becoming calloused to ferreting out prejudicial error, expecting that it will simply be labeled as harmless on appeal. The specific crimes proof that went to the jury at trial that appellant was previously convicted of two separate sex crimes, one sexual contact with a 12 or 13-year-old girl, and the other that resulted in a sentence of 3 years imprisonment, must be overturned as prejudicial to the judicial process. I'm now going to turn my attention, Your Honors, to the plain error ex post facto arguments made in my brief. Both the Tennessee and U.S. constitutions forbid laws that retroactively inflict punishment. The Tennessee Supreme Court ruled in State v. Pruitt that the ex post facto clause of the Tennessee Constitution has the same definition and scope as the federal clause. The Tennessee Sex Offender Registry has been held to be a violation of the federal ex post facto clause on an as-applied basis in the United States District Courts for the Eastern District of Tennessee and the Middle District of Tennessee. Those decisions are based on the U.S. Sixth Circuit Court of Appeals decision in Doe's 1 through 5 versus Snyder, which was rendered in 2016. This issue was not raised in the trial court and can only be considered here as plain error. 5 factors must be present to consider an error as plain. Number 1, the record must clearly establish what occurred in the trial court. 2, a clear and unequivocal rule of law must have been breached. 3, a substantial right of the accused must have been adversely affected. 4, the accused did not waive the issue for tactical reasons. And 5, consideration of the error is necessary to do substantial justice. All 5 factors are present in the case before the court. The state has conceded 3 of the 5 factors and only argues that appellant has failed to show that his conviction violated an unequivocal rule of law or that one of his substantial rights was adversely affected. The ex post facto clause is an unequivocal rule of law.
Well, have we ever held, I mean, you're going to a clear and unequivocal rule of law. I understand based on the standard that you're traveling on. This was not raised in the trial court. The trial court didn't get an opportunity to rule on this. As in Tennessee, have we ever applied any treatment to the sex offender registry in the same way that the federal courts have?
I'm not aware of any decision that has held the same as the federal courts, Your Honor.
Or any treatment whatsoever. I don't mean the same because all the cases you cited, I'm very familiar with, counsel. They are very detailed in how they address the sex offender registry, not just Tennessee, Michigan, Ohio, various other states. That's the treatment that they've given to their sex offender registry. Has Tennessee given any treatment, to your knowledge, to the sex offender registry constitutionally?
Your Honor, there is a decision by the Tennessee Supreme Court that arose out of Memphis, and I'm sorry, but the style eludes me now, but it is a reported decision. And it's somewhat similar to this case in that the constitutional issues challenging the sex offender registry were raised on appeal for the first time. And the Supreme Court noted in that case that because they were raised for the first time, the court could not decide the case. But then the court went on to address those constitutional issues for over 2 pages and recommended that the legislature amend the Tennessee sex offender registry statute as being constitutionally deficient.
So there was no ruling, to the state's point, is where I'm trying to get to. I mean, clearly
there's not been a decision, a Tennessee decision rendered on the same basis as the federal court decisions. That's
Thank you.
why I started out, Your Honor, saying that the Tennessee Constitution had been held by the Tennessee Supreme Court to have the same contours as the the U.S. Constitution on ex post facto law.
I understand. Thank you, counsel.
Yes, Your Honor. My argument is it was plain error to indict and prosecute appellant using the prior convictions as status offenses. Appellant's Missouri convictions predate Tennessee's current sex offender registry law by 8 years. And yet those two convictions have been used as elements of a crime that has resulted in appellant being sentenced to 6 months imprisonment. There are only two showings that must be made to show an ex post facto violation: retroactivity and punishment. Both are present in the case at bar. Thank you, Your Honors.
Thank you. General Orr.
Good morning, Your Honors. Courtney Orr on behalf of the state. May it please the court. I will address the issues in the same order the defendant has, first starting with the stipulation and his sex offender registry status. And in this case, any failure of the state to accept the stipulation that the defendant had a prior sex offense conviction was harmless. Judge Thomas.
Did you concede? I don't remember. I've read so many briefs. Did you concede error?
We did not concede error in the brief. Reading James, I believe a stipulation probably would have been appropriate, Your Honor. I disagree somewhat with the characterization of the holding in Wrigglesworth, and we can get to that. But looking at the proof in this case, any failure to agree to the stipulation was harmless.
I know you want to get there, but give me a chance to get there with you.
Yes.
I cut my teeth on gun felon possession cases in Old Chief, and I went through that process. I cannot think of anything more prejudicial in this case than what counsel has argued. The state admitting convictions with the specific facts of sexual molestation of a minor. I just can't. Can you speak to that? You can't unring that bell. This is somewhat like, trying a convicted felon in possession of a handgun, and you've got, the underlying felony convictions being aggravated robbery or something like that. This is much worse, because what you've got here is the conviction offense being a paper offense. This is a violation of a sex offender registry, basically, and you're putting in convictions that were, by their very nature, offensive and provocative. Can you speak to that?
Well, under Rodriguez, when this court is looking at the prejudicial effect of putting in these prior convictions, the court has to look at the strength of the evidence regarding the rest of the elements of the case. And that gets
you got two elements, counsel. You got
yes.
two.
Yes, but that gets to Judge Thomas's question that there are only two elements in this case, none of which were disputed by the defendant. He did not dispute that he was a sex offender. I'm going to let
you argue.
Okay.
I'm going to stop interrupting you. I apologize.
I'm happy to answer whatever questions Your Honor has, but there were only two elements in this case. One, that the defendant was a sex offender, which he did not dispute. And two, that he was on school grounds at a time when he had reason to believe that children under the age of 18 were present. The defendant admitted in his own testimony that he was on school grounds and that he knew children were there. It was the first day of school. The only issue in front of the jury was whether the defendant could be able to use this defense that he was there acting as a parent. Now, by law, under the language of that statute, that defense is not available to him because he does not qualify as a parent under the statute. But even if we were to assume that this was a proper question in front of the jury, whether the defendant was acting as a parent in a way that would allow him to be on school property has nothing to do with his prior convictions. And the prior convictions would not have affected the jury's consideration of that question before them.
I don't know if that cuts in favor of your argument or defense counsel's argument. Because if your argument holds true, why would what would be the point of it admitting the convictions? I just don't understand that.
I mean, yes, I agree that to the question of whether the stipulation should have been accepted, that would be the first question, and that probably cuts against and why we would agree that a stipulation was appropriate here. But under harmless error, the defendant has to prove, the defendant bears the burden that the admission of the prior offenses would more likely than not have affected the judgment of the jury or the judicial process. And here, that is not possible. The jury was debating a question about whether the defendant was acting as a parent and had two competing testimonies where he said he was, and the child's mother said he was not there as a parent. He was not acting as a parent for my child. That was the question before the jury. And the proof establishing the elements of this case were not only, the proof of it was not only overwhelming, it was agreed to by the defendant. So to the extent that this would prejudice the jury as to the defendant's guilt is just not realistic in this case. Because Rodriguez directs the court within a harmless error analysis to look at the proof of, or the strength of the proof of the defendant's guilt. We submit that because the defendant has not contested any of the elements that prove his guilt in this case, he cannot show that this was the admission of his prior conviction would have more likely than not affected the verdict. I do briefly want to touch on Wigglesworth for his point about the prejudiced judicial process. Wigglesworth is a little bit of a different case. It's not exactly on point with James. In Wigglesworth, the trial court actually held that the stipulation could not be entered and proof of the prior convictions could not go to the jury. But because the defendant had agreed to stipulate, then the question of whether the defendant was a prior sex offender was outside of the jury's purview, and that element did not go to the jury for deliberation. In Wigglesworth, this court held no, both elements had to go to the jury for consideration. The stipulation did not render that jury or that element irrelevant, and the jury had to render a verdict on it. Instead, it had to go back to be retried for proof of the defendant's prior convictions to be presented to the jury, either in the form of a stipulation, which it suggested was correct, the stipulation, or the prior convictions. Here, there is language in Wigglesworth which says that stipulation does not take off the state's burden to prove the element of that offense. The state's, in this case, reading of Wigglesworth appears to be a misreading of that sentence where it thinks it has to prove the actual convictions instead of the fact of a conviction. But we submit this was not a misrepresentation of the case law to the court that would result in a prejudice to the judicial process. And as I have already stated, the proof of the defendant's guilt was overwhelming in this case. Unless there are any further questions regarding this issue, I will turn to the defendant's ex post facto claims. To be candid, excuse me, to be candid with your honors, this issue appears to have developed some through the briefing. And he has argued two different things before this court. First, that the sex offender registry under Snyder is unconstitutional. But as stated in his reply brief, and I believe the issue actually before this court, is whether the defendant's conviction for being on the school grounds itself is retroactive punishment. And we submit that it is not. The defendant, whether he was on the registry and whether he was subject to Tennessee's sex offender registry, is not the controlling question for the ex post facto argument or analysis in this case. Instead, the question before this court is whether the defendant is retroactively being punished for something that was not an offense at the time he was committed. And that is not the case here. Here, he is convicted for being on school grounds while having a prior sex offense conviction. That crime, that statute criminalizing being on school grounds was passed in 2008. The defendant committed his offense in 2018. What is being punished is not his prior sex offenses, but instead the act of being on the school grounds while having a prior sex offense conviction. Judge McMullen, to get back to your analogy about the felon in possession of a handgun, this is similar. He is not being punished for his prior offense. Instead, he is being punished for the act of having a prior conviction and committing this act against the law. That statute was in place at the time that he committed this offense, and there is no retroactive punishment. So therefore, the ex post facto clause is not implicated. Just McMullen, to address also what is in the briefing and what is in his reply brief and what he's addressed today, Judge McMullen, your question was correct. The Tennessee courts have not applied the Snyder analysis to the Tennessee Sex Offender Registry. I believe the Supreme Court case Mr. Lockett mentioned is a civil case in which there is some dicta questioning, but it is not a ruling which says that the Sex Offender Registry is unconstitutional. We have Ward versus State, which is a Tennessee Supreme Court case in a post-conviction posture where I believe the issues were ineffective assistance of counsel in involuntary plea, where the Tennessee Supreme Court said the Sex Offender Registry is not retroactive punishment and therefore was not coming into play in terms of the advice this counsel gave. And we also have Woodson from this court last year, which says that the Sex Offender Registry is not an ex post facto violation. In short, there is no clear and unequivocal rule of law in the state of Tennessee that says that the Sex Offender Registry is an unconstitutional ex post facto violation. And because there's no clear and unequivocal rule of law, there can be no plain error. Unless this court has any further questions regarding the issues discussed here today, I will rest on the state's brief for the remaining issues, and we ask that you affirm the judgment of the trial court.
Thank you. Mr. Lockett, you don't have any rebuttal time left. You argued a little bit in excess of 20 minutes. So thank you all for your arguments and your briefs, and we will duly consider them and the record and issue our opinion. If you would place us in recess, please, Ms. Craft.
This honorable court of Tennessee is now in recess.